Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the fabulous Jake Blake, an Ohio construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the wonderful Jake Blake.
Well, thank you for that warm introduction. I've been a partner at Calfee, Halter Griswold for 4 years and was an associate at the firm for 8 years before that. I've been doing construction law for approximately 12 years and learned from one of the greats in Ohio who, love it or hate it, was responsible for drafting a lot of the construction laws, including the liens laws in the state, and that gentleman's name is Stan Dabrowski. So without further ado, we can get started on our presentation. And I understand if there are questions, you're meant to type them out, and then we'll have a chance to look over some or all of them at the end. So you ready for the next slide? Let's see if I can figure it out.
If you click on the presentation, there you go, you've got it, perfect.
All right, and I think because you're here, you've probably already successfully navigated many of these bullets. So we'll go on to the next slide. Okay, here's the agenda. This is not meant to be super in-depth or deep dive into the law. What it's meant to do is give you, I guess, enough information to be dangerous, or really, as I like to say, know when it's time to reach out for some assistance. And I'll be perfectly upfront. Most of the time, you probably don't need an attorney to help you navigate at least the beginning stages of this process. But I think, and hopefully, what I'm able to relay today, helps you if you're ever in one of these unfortunate situations where you need to file a lien. But I also hope that the information I provide you today will give you sort of the enough familiarity with the terrain so that you know when it's time to reach out for help. And so as you can see the agenda, we're going to talk really briefly about one little contract provision that I think you all should be aware of and try to include, and we'll talk about the reasons why. Some of the very basics on how you protect your lien rights at the outset, and then a reference guide, frankly, for what the timeline is. There's a lot of blocking and tackling that has to occur, and it has to happen in time. And then some common mistakes, and then I'll give you a quick reference to an Ohio where I think some good forms and resources that you can find are, and then SunRay obviously has their own resources. Okay, so the contract, add this one change. Look, one of the most common questions I get when a client calls me with a construction dispute or a contract dispute in general is, I want to get my attorney's fees. And I tell them, well, I need to see the contract. And if the contract does not contain a provision allowing you to recover your attorney's fees in the event of a breach, either for non-payment or something else, you will not be able to recover your attorney's fees, no matter how egregious the breach by the other party was. And even worse, sometimes these provisions, these contracts, are one way, meaning only the other party, if they win, they get their fees. And so one thing I want you to be really aware of is, number one, the American rule. They call it the American rule because in virtually every other country, you can recover your fees in a breach of contract. But the American rule is you cannot recover your attorney's fees for a breach of contract claim unless the contract itself contains provision allowing you to recover your fees. And if you are going to add this clause, I've got here a bullet that says one-sided if you can, bilateral if you must. What I like to do when I make my initial draft of a contract is I'll put in a one-sided provision, meaning only my client gets to recover attorney's fees if they win. It's a great clause if the other side accepts it. And sometimes they accept it because they don't think it's important, or they don't pay attention, or they're not represented. But generally what will happen is when I include a one-sided provision, the other side will propose what I call a bilateral, meaning both sides get the opportunity to recover their fees if they win. If you are going to negotiate a one-sided provision, I always like to include some additional language in the contract which makes it clear that the provision was negotiated. And the reason is that some courts in some states and in some jurisdictions, even within the state of Ohio, will not enforce or will strike an attorney's fees provision if it does not appear to be negotiated fairly and fully by the parties. And so I've given you an example here of a bilateral provision, which is the one that you're more likely to be able to use and take advantage of. And you're welcome to read it there. It's on the screen. But essentially what it does is says, if there's a dispute that arises out of this agreement, and that would include payment issues, then the prevailing party, the party who is able to prove that they were right, is able to receive from the non-prevailing party all of their reasonable attorney's fees. So it's not, if you have a $10,000 matter and your attorney charges you $100,000 to recover that $10,000, there's a good chance that the court is going to find that those fees are unreasonable. But you will be able to recover some reasonable amount. And courts will modify fee requests down to amounts that they believe are reasonable. And sometimes, you kind of look sideways at the court and say, okay, Judge, you haven't practiced law in about 30 years. You don't know exactly what it costs anymore, but you get what you get, right? And then that last sentence there is that sentence I talked about before about fully and freely negotiating the attorney's fees provision. It's important just to give the court some extra comfort that yes, indeed, that the provision was negotiated, that both parties knew what they were getting into. No one was forced to do it or anything like that. Okay, why is this important other than helping you pay for your fees if you have to go after someone for non-payment? Or if someone comes after you for non-payment and it turns out you didn't owe them the money. Why is it important to have this provision? Well, oftentimes when you are dealing with construction matters, you have subcontractors or contractors who are claiming non-payment, but it's a small amount, $2,000, $3,000, $4,000, $5,000, $10,000, something which may not feel small to the sub or the GC, but is small when you start talking about the cost and expense of litigation. And so, while a party can threaten litigation, oftentimes those threats are not serious because that the cost of litigation, I advise my clients this all the time, right? Which is, well, look, it's only $2,500. They're probably not going to really sue you, and if they do lien it, we can always, pay off a lien for that amount. So what this provision does is it provides you additional leverage. I'm not only going to get the amount of money that you owe me, but I'm also going to get the amount of money it costs me to recover that amount. And so it's additional leverage. It changes the complexion of the litigation and frankly the calculus that the opposing party will undergo when they're evaluating how to handle or deal with the breach and the claim. And without this prevailing party provision, there is a point. There's a minimal, frankly, a minimal amount of a dispute where the cost of litigation just isn't worth it. And so this provision helps to avoid that scenario to a great degree. Okay, let's move on to the next topic, which is just securing your lien rights. And I say this somewhat tongue in cheek, but read the contract, then read the contract again, and then read it a third time just to be sure. And why do I say that? The reason is because you can modify to a great degree a lot of your ability to put liens on properties. There might be provisions where if you get paid, you're waiving your lien rights, not just for work that has already been performed and paid for, but also future work. So take a careful look at the way in which the contracts are drafted and how the provisions might impact not just your lien rights, but your other rights as well. And just staying on the topic for your lien rights, I often ask the question about if one of my clients has been liened, or if I'm representing a client who wants to file a lien, I ask, well, did you file a notice of furnishing? And most of the time, the answer is no. And that's okay, because you only are required to file a notice of furnishing if a notice of commencement is filed. And the notice of commencement typically would be filed or recorded and served by the owner. And if the notice of commencement is filed, then that is supposed to give notice to all of the suppliers and subcontractors that they need to let the owner when they're supplying services. And they do that by serving a notice of furnishing. And those are very simple, and I'll give you a link to where you can find some forms for a standard template notice of furnishing. But there's another exception to the notice of furnishing, and that's if you are in direct contract with the owner. So if the owner and you have a contract, you are in what's called privity. And that's different than an owner contracting with a general contractor who then contracts with a sub or a sub of a sub or so forth. If you're a first tier or second tier sub, meaning you're not directly in contract with the owner, that's when you need a notice of furnishing. But I always like to err on the side of caution. Again, you'll see if you look at the resources I've provided, the notice of furnishing is a very simple form. And if you provide the notice of furnishing, if you serve the notice of furnishing on the owner, at least there's no question. Then it doesn't matter. Was I in privity? Was I not in privity? Was a notice of commencement filed or properly filed? Doesn't matter. If you just, before you show up or when you start work, provide the notice of furnishing, you don't have to worry about trying to look at the law or look at the facts to determine, did I do what I was supposed to do? It's a very simple document. And then there's actually some, very technical, but easy to foot fault on how you record your mechanic's lien. It's got to be notarized. I can't tell you how many times I've had a client come to me and say, my property's been liened. I received this in the mail. It's an affidavit of mechanic's lien. Maybe it was even recorded in a recorder's office. And I look at the thing and I say, no, your property hasn't been liened. And they're like, well, what are you talking about? It's like, this thing's not notarized. You've got, there's no like close enough, right? This isn't horseshoes or hand grenades. Mechanic's liens are, the statute is written very precisely. It's written to help subs and suppliers protect their lienable rights, but it's also hyper technical, and a mistake in timing or form will torpedo your ability to lien the property. And even worse, if you think you lien the property and you did so within the time that's prescribed, and we'll get into that here in a bit, but you somehow committed an error which would invalidate your lien, and then you go back to try to fix that error. If the time has expired, you are out of luck. I hear a lot of my subs say something to the effect of, well, I'll just wait till the last day and then I'll put a lien on it. And I always counsel, no, give yourself a week or two in case there's a problem, and then you can go back and fix it if preserving the lien right is important to you. All right, so sign it in front of the notary, file it in the county recorder's office in the county where the property is located. And I cannot emphasize this enough. Go onto the county recorder's website or call the county recorder themselves and just ask them, hey, what is the format I need to file these documents in. I'm trying to file this or record this document. What format does it need to be in? And they all have kind of goofy requirements for margins and for how big the font size can be and how much space you need to leave on the first page versus the second page. Usually it's 3 inches because they need to put their stamp on it. If you don't do that, you're going to show up and one of two things are happening. Either they're going to reject the filing, reject the record. And again, if you're at the end of the day on your last day, you're going to be out of luck. Or they're going to charge you more, and it's not prohibitive, but let's say it's $20 a page, maybe it'll be $40 a page if you don't have your stuff set up in the right format. And like I said, if you call the people at the recorder's office, they're very likely to help. The other thing I can say about recorders' offices in general, particularly if you get into smaller or more rural counties, is they sometimes have odd hours. I've sometimes driven an hour and a half across the state, show up at a place to record something in a recorder's office, only to find that on Thursdays from 12 to 4 they are closed. They generally all close at 4. Some of them close at 3:30. Some of them are open every other Monday. Some of them are randomly closed on the odd Wednesday or Thursday, and it just behooves you to call ahead, check the website, make sure someone's going to be there to receive your filing. And then once you get it recorded, they'll stamp it. They'll give you a number, a record number, and then you got to serve it. And you serve it on the person who owes you the money. So if that's a sub that you've contracted with, or a general contractor that you've contracted with, and the property owner, right? So if you are serving it on the person who owes you the money, it also behooves you to serve it on the property owner as well. And that's twofold. One, the statute requires you to do it. But number two, that is the thing, if you're a subcontractor looking to get paid, that's the thing that will get you paid quicker than anything else. Is if the owner knows what that the property is being liened, the owner will then put pressure on the GC, more pressure than you can. The owner will then put pressure to make that payment, and it's generally because the contract between the owner and the GC, usually, and if you're a general contractor or if you have a subcontract that is a bit more robust, you're going to have provisions in there which require you to keep the property free of liens. That's generally why it's not only legally required but just functionally a good idea. I've just put the times on there. We'll go over the timeline a little more detail here in a second, but just bear in mind, commercial, residential have different times. You have different deadlines, and it's not from the day you start. It's your last day of work. Okay, so the last day you perform your work. What's work? We'll get into that here in a bit, but work is not probably everything that you think it is. Okay, here is the timeline, the lien law timeline, and I've just put all of the functions on there. So whether or not you're the owner or the GC, or sometimes the GCs are, the owner asks them to do the notice of commencement, so on and so forth. But you got to do it at the beginning of the project if you're going to record the notice of commencement. And then if a subcontractor starts work and they're unsure if a notice of commencement has been recorded, they can request, and the owner has 10 days to provide. And if they don't, then that would alleviate your need to file the notice of furnishing or serve the notice of furnishing. But like I said, the serving the notice of furnishing is a very simple thing to do. And if I could convince my clients to just do it anytime, even if it's not necessary, it would save a lot of heartache and questions when these things go wrong. We just talked about 75 and 60 days for commercial and residential for last work of materials, and if you're going to serve and record a notice to commence suit, you have you do that after you receive the mechanics lien from the person filing the lien, and then you have to record that notice to commence suit within 30 days of actually serving it on the lien holder. And all that does is it starts a 60-day clock. And here you go. This is the complaint for money and to foreclose on the mechanics lien. So if you file if you file a lien and you receive a notice to commence suit, you will have 60 days to file your lawsuit to foreclose on the lien and collect money damages, and likely for non-payment. If you don't file your notice to commence suit within the 60-day time frame, it's okay. You just lose the right to continue your lien. You can still sue the other party for non-payment, for breach of contract. You just won't be able to continue to cloud the title or keep your lien on the property enforced. And then if no notice to commence suit is served, so let's say you're not paid, you go and record the mechanics lien, you then serve the mechanics lien on the owner and the GC, and then no one does anything. It just sits there. The lien itself will dissolve. The lien itself will cease to become operative after 6 years. I've never seen that happen, but never is a long time, and I assume that it has. It's frankly probably just a clearinghouse mechanism to get rid of liens that are languishing there in limbo. But that's just something to keep an eye on if you're in one of these protracted disputes and no notice to commence suit is served. The last thing I have on this timeline is the recording the affidavit of release, and this is very important. Let's say you've obtained your lien, you have a notice to commence suit was served, maybe a complaint was filed, and there's litigation. At some point, 99% of the time, the parties to the dispute will resolve things, voluntarily, either through some sort of settlement or some other mechanism. And when that happens, the owner, usually the property owner, is going to want you to release your mechanics lien. And how does that happen? Well, it happens kind of the same way that you file the lien, except for you fill out a different form that references the affidavit of mechanics lien and where it's recorded and so forth. And then you will actually record that in the same county recorder's office that you filed the mechanics lien. And you have 30 days to do that after either settlement or if there's been some payment ordered by the court or so on. And if you don't do it within the 30 days, and this is the important part, 30 days seems like a long time, but if you fail to do it within the 30 days, you can be held liable for clouding someone's title to their property. Now, what would the damages be? Well, it depends on what they were trying to do. I mean, if they were trying to sell or mortgage that property within 30 or, on day 31, and they couldn't do it because you didn't release your mechanics lien, well, you might have some liability for their inability to go forward with that transaction. So, this is, again, basic blocking and tackling. You just make sure you file your release. Okay, we'll talk briefly here about some traps to avoid. And this goes back to my first thing I said about reading the contract. Make sure you aren't waiving your lien rights in the agreement. It can happen. It has happened. So read carefully. And another point we touched on earlier, don't take a chance. Don't try to evaluate without the aid of a lawyer whether or not you're in privity, whether or not you have a direct contract relationship with the owner. Just serve a notice of furnishing. It's very simple. Figuring out when the date of last work or last furnishing can be tricky. We said 75 days for commercial, 60 for residential. So what counts, right? Well, last work or materials specified under the contract were furnished. That's the time, right? So that doesn't include warranty work. So if you go back out to the property and do some warranty work, that doesn't restart your clock. Punch list items may count, and that really depends on whether or not how much the punch list items themselves are specified in the contract. Like if there's a payment provision specified to completing punch list items before final, final turnover, then that might be considered your last day of work, but it might not. So be careful with that. I always, again, I never advise clients to wait until the last day to file their lien, because when you start counting and whether or not your initial filing will actually check all the boxes, that's kind of a risk. And pay attention to your pay apps and the lien waivers that you sign. They may be broader than intended. Again, this goes back to waiving your rights. I use the word complicated. I suppose as statutory schemes go, it is not complicated, but there are a lot of details. There's a lot of connective tissue between the provisions that create, like I say here, potential pitfalls. And so, there are lots of websites you can go on and learn about that. And some of that learning is good. But, also, obviously don't believe everything you read. So what I have included here is what I think is a fantastic resource if you're just looking to get some templates for these forms we've talked about. They have examples of all the forms you'll need. It's right there at the Franklin County Law Library. And if you don't have access to this link, you can just Google Franklin County Law Library lien, mechanics lien forms. It'll take you right to this page. But that has a listing of all the forms that we've talked about today, plus some others. And you can download those and use them for your purposes. I think they're pretty self-explanatory. They're kind of paint by numbers, fill in the blank. But what you shouldn't do is if you need to file a lien, and I've seen this happen before, you go online and you just say mechanics lien and you download it and you fill it in partially and then submit it. And I actually had a client come to me and say, hey, I've been liened. And I said, well, let me see. And they showed me the lien that was recorded, and the work that was done, or the work that was described in the lien, was for a roofer. Well, the sub that my client had hired was construction cleaning. So what had happened is the subcontractor had just gone online, downloaded a form from some roofing company, and filed that as their mechanics lien. And so what did I tell my client? No, you haven't been liened. This lien is invalid. It was incidentally, even though there was an invalid lien, the subcontractor was smart enough to serve the owner, and the owner called up my client and was like, hey, we got to get this thing taken care of. And even though we were able to tell the owner, hey, your property's fine, nothing is liened, they still wanted us to clean it up. So again, probably the most important thing you can take away from this is if you don't get paid, complain to the owner. The owner is probably going to be your best ally on that. Talk to your local county recorder's office, right? Or I say local, wherever you're going to file it, right? And you should record your lien in the county where the project is located. And then if the project is big or the issues are convoluted, or if you just have questions, right, call up a construction law attorney. Google is a good resource for that. You can Google. You can certainly reach out to me, and I'll be happy to help or point you in the right direction for someone that can help. Okay, there's a quiz here. You don't have to, I think, answer audibly, but
all right, so I'll go ahead and I'll pop on here now, Jake. Thanks so much. You were incredible.
Yeah.
Yes, If anyone does want to take a look at these questions, we're testing your knowledge a little bit. And if you can answer correctly into our chat, we'll go ahead and send you guys over a free little gift. First of all, while this is on the screen, I did have a question that came through, Jake, and I wanted to make sure we addressed it for them. It says, as a supplier, how is the best way for us to handle prevailing provision into our process? When we have a sub or GC fill out a job sheet, should we be including terms and conditions to go along with that?
100%. That's a great question. Terms and conditions are your friend. I still find, particularly for suppliers, because a lot of times your paper trail is purchase orders and invoices. I still find suppliers that don't have terms and conditions, and they get into a dispute with a customer, and the customer is going to have terms most likely, and those terms are probably going to be pretty egregious. They're probably going to have a one-way attorney's fees provision. They're probably going to have a venue provision that you don't like. They're probably going to limit liability that in a way that you don't like. So it's important to have your terms as both a defense against the other side's terms and as offense. And I would definitely think about engaging an attorney if you are looking to draft terms from scratch.
All right, great, thank you. Can you go ahead and go to the next slide for us, please? Perfect, thank you. All right, and then we did have one other question that came through, and it says, does Ohio have a standard form for a lien waiver?
Like a pay app or lien waiver. I don't believe there's one on the Franklin County website. And if you're a owner who's going to be managing subs, or if you're a GC who's going to be negotiating contracts with subs and want to put together your own pay application with lien waiver, I mean, certainly you might be able to Google something and find something that's reasonable. That's another one that I would say reach out to a construction attorney, and they can relatively quickly probably send you a form that they've used 100 times. I know I have, a folder full of old forms, and they all have lien waivers, and they're all about the same, more or less. And again, with those, my general practice, whether I'm an owner, representing an owner, a GC, or a sub, is you just waive the stuff that is being paid for. That's it. You don't waive anything else. So if you're getting paid for the work, you no longer can lien for that work.
Correct. Thank you so much. I appreciate that. Yeah, just with those waivers, make sure that you guys are really paying attention to the language that's on there and making sure it is what you're trying to accomplish and waive the rights to. Generalized statements are really hard, so be on the lookout for conditional or unconditional release terminology and language. All right, if anyone does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any other questions for you. Can you go ahead and go to the next slide for me, please, Jake? All right. So here are some of SunRay's resources here to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead, scan that QR code to access these incredible resources. We've got our deadline calculator, project information sheets. If you're doing work in a state that you are not familiar with, you can go ahead and go to our state lien laws rules, click on that state, and it will break it down, whether it's residential, commercial, state work, and then what your role is in that project, and it will tell you what types of documents you need and what those deadlines are. So go ahead and scan that so you can access those resources. Can you go to the next slide, please? All right, so we have our new service at SunRay. SunRay Receivables will be helping you handle your collections for you. We're here to help get you guys paid. Give us a call, send us an email so we can help you out. All right, next slide, if you don't mind. All right, our next webinar with Jake is going to be Don't Sign a Release Unless It Says This One Thing. That's going to be on October 2nd at 10 a.m. Eastern. Go ahead and sign up for free at sunraynotice.com/education. We'd love to be able to see you guys there. Next slide, please. If you don't mind, take a moment to review us, give us your feedback. It always helps us improve ourselves in our webinars, as well as get this information out to other contractors and suppliers like yourselves. And then last slide, if you don't mind, Jake. With that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you at our next webinar. Again, Jake, you were incredible. Really, really big thank you to you. And I hope you all have a wonderful and beautiful sunny day. Thanks, everyone. Have a nice day.